Our next speaker, I don't think he'd like to be called a millennial, but he's certainly up there with all the tech stuff. Nick Rosslee. He's an associate working in a team that focuses on brand management, protection, and commercialization of brands. He assures me that he stopped supporting Manchester United at the age of 12 because he thought it was too mainstream. He regularly posts on Instagram pictures of his mates' dogs. He doesn't have a dog, so this is quite strange. So over to you, Nick.
Hi there. My topic, daring to be bold, really comes on the back of the cases that were discussed earlier. The recent cases, Yappy Chef, Makate, MoneyWeb, Clearview, and also my chat with Simpiwe last week. What the big point I'd like to drive home to you today is that originality, creativity, and inventiveness is the lifeblood of intellectual property law. And if you want your brand, your business, and your product to get the full benefit of the intellectual property laws out there, you really have to dare to be bold. The foundations of intellectual property law were laid in Venice in 1474, where the first patent law was ever passed. The patent law read, "Any person in the city who makes any new and ingenious contrivance not made in our dominion shall, as soon as it is perfected so that it can be used and exercised, give notice to our office, and it will be forbidden for up to 10 years for any other person in any territory and place of ours to make a contrivance in the same form without the consent and license of the author." When we look at this patent, what are the key requirements here? Novelty, ingenuity, proof of usefulness, the requirement to describe and explain your invention, and in exchange for that, you're getting a monopoly for 10 years. How does this resonate with my topic, daring to be bold? Well, no, it doesn't. No, it does. I'm just joking with you. This 600-year-old patent is practically identical to the patent laws of today. You contribute something new, ingenious, and useful into the public domain, and you get rewarded with a monopoly. This is effectively the rationale of intellectual property law. We call the forms of IP the IP law recipe, and this encompasses 5 different forms of intellectual property: patents, copyright, trademarks, designs, and know-how or trade secrets. On this slide, we have the requirements for IP protection in South Africa. For patents, is your invention new and does it have an inventive step? For copyright, is your work original and fixed in a material form? For trademarks, is your brand capable of your trademark capable of distinguishing your goods from the generic goods of everyone else in the market? For designs, is it new and original, or is it new and not commonplace? And for know-how, is the information confidentially held, and does it bring a competitive advantage? I'm highlighting the key areas here, the key words that really will jump out at you. And that links back to my original thesis, that originality, creativity, inventiveness, and distinctiveness is the lifeblood of intellectual property law. So I'm going to briefly discuss 3 cases that demonstrate my point. 2 of these cases have been discussed by the panel, which includes the chairman, Gerard du Plessis. And so in some respects, I feel a little bit like speaking after the father of the bride at the wedding. So the best thing I can do is try to keep it short. The MoneyWeb versus Media24 case, what really you need to take home from this case is that you cannot merely say that something is original and that you've expended the requisite skill and effort to get this. You really have to show the court why your work is original. You can't just state it. And they could have done a lot better in stating it, but they could have also just written a lot more original articles based on what was said in the press conferences. You can't just merely restate what was said in the press conferences. The Yappy Chef versus Yappy Gadgets case, we've discussed extensively. What they're trying to tell you in this Yappy Chef case is that you cannot just get a monopoly in a word that is there in the dictionary. And in this case, the word Yappy. They're not going to extend the courts are not going to extend your monopolies too far. But if you had a wholly distinctive word that wasn't in the dictionary, you would be able to enforce it against just about everything. And then the Pepcore versus Trueworth case, which we can call the look. This case has not been discussed by the panel, so I can give you a little bit more of the facts, but I do have a time limit and a snooze pillow over here. So the facts of this case are that Trueworths had trademark registrations for the word mark the look in respect of, among other things, retail and fashion. Pepcore's department store Ackermans used the phrase the look for less in its in-store advertising, and on this basis, Trueworths brought infringement proceedings against it because they were using a mark that wholly incorporated its mark, the look, in its the look for less tagline. What Pepcore did is they brought a counter application against Trueworths and said that your mark, the look, is not distinctive and it should never have been registered. So what they needed to demonstrate to the court was that their mark actually was distinctive. And you can do this in two ways. A mark can be distinctive either inherently, and that would mean that it's completely original in respect of, in this case, clothing and fashion. And the court said it's clearly not. The other way that you can demonstrate that your mark is distinctive is through use. And even though Trueworths had over 100 million rands worth of sales with swing tags on that had the look on, it was still used in conjunction with its more dominant trademarks, Trueworths or Basics. So it held that the maxim, use does not equal distinctiveness, stands in our law. So in this case, the court decided your mark is not capable of distinguishing your goods, Trueworths, against the other products in the market because it's basically descriptive of fashion or clothing. And the trademarks were removed on this basis. So this case demonstrates potentially your worst case scenario. Your trademarks get removed from the register. You've got a cost order against you, and worst of all, you're in Bloemfontein. So what I'd like to leave with you today is when you leave, you're all in this room because you love IP law and you want to learn more. But if you really want to get the full scope of protection from IP law, you need to ask yourself, are you original, are you novel, are you distinctive, and are you inventive? And what this slide aims to show you is the more you are on the right side of the line and the less ordinary, commonplace, generic, or descriptive you are, the more IP laws are there to protect you. So that is why my topic, in light of all the recent cases and in light of what the intellectual property laws actually say, what you need to fulfill the requirements to get that protection, if you really want IP law to be in your corner and for you to really have a strong protection for your business, your product, or your brand, you've got to dare to be bold. Thank you.
Hi,
Hello,
it's
Alicia.
Alicia from Adams. It's maybe not a question for Nick, but just a question. Clients often say, you want our trademarks to be bold and distinctive and inventive, but that doesn't sell. What sells is the descriptive thing that describes the product. How do you suggest we find the balance between the Nikon for cameras and, I don't know, something a little bit more descriptive so that you can sell your product?
Yeah. Thanks for the question, Alicia. So obviously I was really looking forward to that one. Obviously on so you've got a spectrum of things between completely ordinary and completely made up and inventive. And on the ordinary side would be bread for bread, which is completely descriptive. You'd never get that as a trademark. You can call your bread bread, but you've got no protection from the law. On the far side is completely made up words, which involve Nikon, Nike, Kodak are some of the famous ones. But then somewhere in between the two are suggestive marks. So words that that allude to a special characteristic of that product. So if you look at the cars out there, you've got lots of cars named after horses, which suggest elegance and speed. So that would be, if you can find something that's not descriptive of your goods, but perhaps through analogy, you're able to suggest that your mark has these classic characteristics that you want to demonstrate. An animal or something like that could be a good angle to go on. Thanks.
Hello. Hi, my name is Pundo from Bitmobites.
How's it?
Okay, my lawyer is actually an ex-Adams and Adams advocate. Her name is Butleli Kokotla from Victor Mnege now, as well as another guy called Godi Sinene. Those guys are working with me right now, created something very, very new. It's a computer software. But then we went through all the laws and everything, and we found out that we can't actually put a patent on it because actually computer software itself has a patent. So we can only trademark it or copyright it and all that. So she then made an example that even though Mixit released an application, doesn't mean that WhatsApp couldn't launch because of Mixit now. So I wanted to find out if there's any other protection besides trademark and copyright, because it seems like the only protection we have now as a completely new product that does something completely new is the fact that we need to launch in the market first, and people know us first as the product that does is like Skype, and then by the time Snapchat comes over, everybody knows Skype first. So our only advantage is hitting the market first.
Yeah, we're going to be discussing the patentability of apps on a panel later with Johnny Fiandera, so we'll touch on some of those topics, and perhaps you might be able to walk away with an idea that perhaps there is something patentable about your inventions. But I think you answered your own question there. Your number one route is, if you don't have a patent, is to be first to market and build a brand and build an empire before anyone else gets there. I think that's your best protection, and building a strong brand around that. Thank you.
Right. Thank you very much, Nick.
Thank you.